Hello, and welcome to Colorado Victim Rights Act, providing victims with rights throughout the criminal justice system. My name is Kim Branham, and the Victim Rights Act Specialist with the Division of Criminal Justice. Just to begin, I'm going to give you a little background on the history of the Victim Rights Amendment. In 1982, President Reagan had an assassination attempt made upon his life. He realized at that time that he didn't have any rights as a victim. Now, being the president, he probably had more rights than you or I did if this had happened to us back then. But what he did is he created a task force, and he asked that task force to go out to the United States and to all victims of crime and speak with them and ask them what they liked about the system, what they didn't like about the system, what they wanted to change. And when that task force went out, talked to all the victims and came back and reported to the president. They reported that we were in a national disgrace on how victims were being treated by the system. And had victims had the opportunity to do this all over again, they never would have done it because of being victimized by the system itself. So this is what got our Victim Rights Amendment started. Today, we currently have 37 states that have constitutional amendments afforded to victims' rights. Colorado passed on November 3rd in 1992 and went into effect on January 14th, 1993. This is a map that shows the states that have a Victim Rights Amendment and states that do not have a Victim Rights Amendment. Now, as you can see, there's more that are in green that have a Victim Rights Amendment. The ones in red doesn't mean that they don't have some form of victim rights, they just don't have an amendment. So if there was a violation of a victim's rights, there's no constitution to back it up, and there's no compliance process, which at the end I will go into a little bit more detail as what Colorado's compliance process looks like, and how we handle those types of cases when we do get complaints. So our Colorado Constitution, Article 2, Section 16A, talks about how victims have the right to be heard when relevant, informed, and present at all critical stages of the criminal justice process. These three words, heard, informed, and present, were the words that came back to the president from that task force that victims felt that they weren't receiving. They weren't heard when they needed to be. They weren't informed of the status of their cases, and they weren't present at certain critical stages in the criminal justice process. So our legislative declaration, we intended for this part 3 to assure that all victims of and witnesses to crimes are honored and protected by law enforcement agencies, prosecutors, and judges in a manner no less vigorous than the protection afforded to criminal defendants. I think this is very forward-thinking, and a lot of times when we get through that criminal justice system, we realize that victims are not treated as well as criminal defendants. And I think this is something that we are working on and we're striving for, that at some point in our lives we would like to see that victims are treated better than our criminal defendants. Core victim rights to be treated with fairness, respect, and dignity. And that's very broad. That's probably our number one complaint that we get here at the Division of Criminal Justice, and it's also the hardest to prove. But it's that victims want to be treated with fairness. They want to be treated right, and they're treated the way that you or I would want to be treated. So, for example, not being talked down to, or being felt that they had too many questions, or they were wasting too much of your time. That would kind of fall under a fairness, respect, and dignity piece. The other portion is the informed, present, and heard, which we're going to see this kind of pop up throughout the presentation today. Certain agencies have responsibilities to the Victim Rights Amendment. Automatic agencies are law enforcement, district attorney's office, judges and courts, and the Division of Youth Services. These are the agencies that receive services automatically. They don't have to opt in to receive victim services. Those agencies that do have to opt in for the notification are your local jail facilities, probation, community corrections, Department of Corrections and Parole, and state hospitals. The victim has to ask to be notified of these. Not all crimes are covered by the VRA. The way I like to usually describe it is that all your crimes that are person crimes are going to be underneath the VRA. We'll start with domestic violence. Any case that is domestic violence is considered a VRA. So you may have a case that is harassment, But if there's harassment with domestic violence, then it's a VRA. Harassment itself is not a VRA crime, but as soon as that enhancer for domestic violence has been added, it becomes a VRA crime. Careless driving causing death, child abuse, crimes against at-risk adults and juveniles, crimes involving child prostitution, bias-motivated crimes. And with any of these VRA crimes that we talk about, it's any criminal attempt, conspiracy, solicitation, and accessory to any of the above crimes. Human trafficking, menacing, retaliation against victim, witness, judge, prosecutor, or juror, stalking, tampering with victim or witness, failure to stop at an accident resulting in death and serious bodily injury. Now, serious bodily injury is in yellow because it is a right that was just added to the Victim Rights Amendment in 2017, so it is a new one. Vehicular assault, manslaughter, criminal negligent homicide, vehicular homicide, murder in the first and second degree. All of your assault cases, first, second, and third, as well as kidnapping, first and second degree kidnapping, first degree burglary. Now, first degree burglary, kind of when I started this, I talked about that it's a person crime. And burglary, a lot of people don't see burglary as a person crime, okay? But we have decided to add the first degree burglary to this because a lot of times with first degree burglary, you're going to also see another crime that is also a VRA crime. So typically it's kind of a menacing charge. There might be an assault charge that is added to it. But just know that it's only first degree first degree burglary. It is not second degree or third degree burglary, only first. Robbery, aggravated robbery, and aggravated robbery by controlled substance is also listed. Okay. Any of your sexual crimes, so sexual assault, crimes involving prostitution, sexual assault in first, second, or third degree, unlawful sexual contact, sexual assault on a child. And again, here's another one in yellow because this one went into effect in 2017. Posting a private image for harassment or financial gain. So kind of like your revenge porn, that's what we would consider under that. Crimes covered by the VRA also include invasion of privacy of sexual gratification, incest, indecent exposure, violation of criminal sex assault, and stalking protection order. So we've always had violation of criminal protection order for sexual assault and for domestic violence, but in 2017 we added the stalking for the protection order. Again, sexual assault on a child by one in position of trust, and sexual assault on a client by a psychotherapist. So when we classify crimes of domestic violence, the crime of domestic violence can be added on by the district attorney's office. It could be added on by law enforcement, and it could also be added on by the court on record or in writing. So if law enforcement is on scene and they're not quite sure if it is a domestic violence case and they want to look into it a little bit more, they may want to investigate it, they may not add that domestic violence enhancer right off the bat. Okay, it may not get until it gets to the district attorney's office, where the district attorney's office is looking into it. Maybe their investigator is researching the case a little bit more, and they determine that domestic violence is definitely a part of this crime. The district attorney at that point can add the charge of domestic violence. As the same with the court, as long as the court does it on record or in writing. Okay, when we talk about the definition of a victim, it's a natural person, so it can't be a corporation. It has to be an actual person. And I always like to read the second one verbatim. It says, unless the person is accountable for the crime or a crime arising from the same conduct or plan as crime is defined under the law of the state of the United States. Okay. What this means is your typical bar fight. So you may have two individuals who are in a bar and there's an assault, and one individual is assaulting the other one, and the other one turns around and assaults that one. So both parties are engaging in a criminal act at the time. They are both assaulting each other. Now, if you have one person who is assaulting the other and the other one does not fight back and does not assault them, then you clearly have a defendant and you have a victim. And at that point, that person, that victim, would start receiving victim rights. Okay. And then if such person is deceased or incapacitated, then that person's spouse, parent, legal guardian, child, sibling, grandparent, grandchild, significant other, or other lawful representative could be considered a victim in the case. So maybe the guardian ad litem. You may have social services that may be involved if there's child cases that the child is the victim. Something like that could be considered a lawful representative. And any child victim that turns 18 during or after the case can request to be the primary point of contact. So if this child is 17 years old when the crime took place, and then throughout the duration of the case they turn 18, at that point they can start receiving all their victim rights themselves. It does not have to go through the lawful representative, or it does not have to go through their parent. They can make that choice. Now, if the victim wants to continue to have you provide notification to the parent as well as them, that's their choice. But you can have that conversation with the victim what they would prefer to have. So dual arrests impacting the definition of a victim. Again, we'll kind of talk about the accountable for the same crime. So you may have a law enforcement officer that goes on scene and cannot determine if there's a primary aggressor. Both parties maybe have scratch marks, have bruises, have something on them that you can't determine that one is a victim and one is a defendant. So at this point, maybe both parties would be arrested at that time, and then it would be up to that law enforcement agency to investigate it to determine if there is a true victim in this or if they are both co-combative. It could also be up to the discretion of the district attorney's office to determine this as well. And at that point, if both parties are arrested, and then at one point they determine that the victim is there is a victim in the case, and that becomes the true victim, and at that point they would start receiving their rights immediately. Okay, so when does a reporting party meet the status of a victim? When law enforcement opens a criminal investigation into one of the VRA crimes that we already went over, the person remains a victim unless the case is closed or unfounded, charges are declined, and make sure that the victim has been notified of this, or the defendant is acquitted, and again, make sure that the victim has been informed of this. Okay? If the case is unfounded, the victim may still be eligible to receive some sort of victim assistance, such as crime victim compensation, so make sure that these resources are provided to the victim at that time. After initial contact, law enforcement will provide this information to the victim, typically in writing. It's going to be in a brochure status. Most of the time, agencies, police departments, sheriff's office, they have a brochure that has all of this information in it. Now, everything that's in this orange color the victim has the right to know that these services are available to them. So they need to know that there's a copy of the victim rights and who to contact if they feel their rights have not been provided. So typically what we're going to see in that case is they're going to have my contact information, the Division of Criminal Justice, maybe our main line, my direct line. So if a victim feels that their rights are not being upheld, they're being violated in one way or another, they know how to get a hold of us to file that complaint, or so that we can look into it and resolve it at the local level. The availability of services and resources. What's available to them? Do they need resources? Do they need counseling? Do they need financial support? Do they need a place to stay for the night? So letting them know that what's available to them. The availability of compensation benefits. So when we talk about what's available to them, it's always good to let them know that these are your rights, that you need to know that these are available to you, that doesn't guarantee that you're going to receive these services. So victim compensation, it's an application that they have to fill out, and they have to request the funds, and it's up to the Victim Compensation Board to approve those funds if they've received them or they do not receive them. So that's why it's always good to let them know that it's available to them, but that doesn't guarantee that they will receive them. Okay. The availability of protection, including protection orders, the availability of the police report, and this is their one right where they do have the right to receive something. They have the right to receive a free copy of the initial incident report at the discretion of the agency. So what this may look like is that the law enforcement agency may not want to release that right away to the victim. They may want to wait until the case is closed before they provide it to them. There may be other reasons why, but the victim has the right to receive a free copy of that. A lot of times we'll have victims that contact the district attorney's office and ask for copies of that, and the district attorney will tell them, no, you're not allowed to have that, but it is their right and it's law enforcement's responsibility to provide that to the victim. Okay. So these are some of the requirements for law enforcement. They need to provide the victim with the case number, the name and contact information for the assigned officer. So if they have questions on the case, they can get a hold of that officer and they know who's going to be investigating their case. The address for the district attorney's office and how to get a hold of the district attorney. Informed when the suspect is taken into custody, and the jail notification process. So when we talked about earlier about those agencies that provide automatic information to the victim, law enforcement was one of them, but the jails were not. So a victim has to opt into that jail notification, but it is a requirement of law enforcement to provide that information to the victim. So whether that's contacting the jail directly and signing up with it, if that's going online, or phone, trying to register through the VINE system, whatever it may be, it is law enforcement's requirement to provide that information to the victim. Informed about what steps can be taken into the case of harassment by the suspect. So if the suspect is harassing them, how to get a protection order, how to modify a protection order, what other steps they need to take to maybe file new charges, make a report of that. And then the return of property when it is no longer needed for evidentiary purposes. This a lot of times is going to be up to the district attorney as to when that evidence can be released. The reason for that is because the district attorney's office has their case, and if they're going to need that evidence up until the final disposition of the case, they may need it until then. The district attorney will contact law enforcement and let them know that it is available to the victim at that point and whenever they can have it back. And then it is the law enforcement's responsibility to release that property to the victim when it is available. Again, the case report number needs to be provided to the victim, name and contact information of the officer assigned to the case, and the telephone to the DA's office. Information of the status of the case. What we're talking about of status of the case is if the case is open, if it is closed, if it's filed with the district attorney's office, and then a handover from the law enforcement agency to the district attorney's office, the district attorney's phone number, their address, how to get a hold of them. If a warrant was submitted, if there's a summons that was issued, if there's a misdemeanor declination, and a status change would be considered investigation is still open and pending, administrative open pending, if the case is unfounded, closed in the interest of justice, cold case status, if it's been reopened or it's inactive. And we talk about warrant status. When we talk about warrant, it's the agency who issued the warrant needs to notify the victim when that defendant has been arrested. So if it's your warrant, it's your VRA notification. Even if they may be arrested in a different county, it is still the agency who issued the warrant. It is their responsibility to contact the victim and let them know that they've been arrested. Some responsibilities, there's an overlap between law enforcement and district attorney's office. Again, we already talked about the return of property and how it's at the discretion of the district attorney's office to release that property, but then it is law enforcement's responsibility to provide that information to the victim that they can receive their property. The property needs to be returned within 5 working days on request of the victim. Information of a no-file decision. On misdemeanor cases, it's a law enforcement's responsibility to notify the victim that there's a no-file decision. And then if it's a felony case, it's the district attorney's office, unless there's an MOU in place that states something different. I know certain counties have it set up where the district attorney's office notifies on all misdemeanor as well as felony cases. But the majority of our counties in Colorado have it set up where misdemeanor is law enforcement's notification and felony is district attorney's office. And then how to request protection of their address pursuant to the Colorado Rules of Criminal Procedures. Both law enforcement and district attorney's office need to let the victim know how they can do this. So again, protection orders, how to inform the victim on how they can get a protection order, how they can get that protection order modified, as well as Social Security information. All the victim's Social Security information should be redacted from any information before it becomes public record. This is a district attorney's as well as a law enforcement agency's responsibility. We talk about municipalities. Municipalities don't have responsibilities under the VRA. We would like for municipalities to practice and do it as a best practice that they provide victims the same rights as if it were in a district court or county court. However, they do not have the responsibilities to the VRA. So some tips to kind of consider when you're working with a victim. Remember the tone and voice and the words that you use with the victim. Again, this kind of goes back to that fairness, respect, and dignity. And we have gotten many complaints about law enforcement and how officers maybe speak down to them. They're rushed through the conversation. They need to hurry up and get on another call, whatever it may be. But taking that time, slowing down, working with that victim, providing them the information. Okay? If there's a victim that is contacting your office and calling over and over and over and leaving messages and that officer doesn't call them back or the victim advocate doesn't call them back and follow up with them, maybe trying to find out, reach out to that victim, even if there's not an update on the case. Maybe that's all they want. Calling them back, telling them there's no update on your case. As soon as there is, somebody will be in touch with you. But remembering to return that phone call. Okay? Remembering the tone of voice that you're using when you return that phone call. Document, document, document. I can't say that enough. We get many complaints that come in, and the officer will be talking to them. And they're like, yeah, I know that I told them, but they didn't put it in their report. So if it's not in a report, it didn't happen as far as our VRA subcommittee is when they start determining if there's a basis in fact for an allegation. So document everything. Always include one sentence in your report to reflect that the victim was provided that victim rights brochure. So when we very first started talking about the law enforcement responsibilities, and there were the responsibilities that were available to victim in the orange colored sections, all that information is going to be in that brochure. So that needs to be in a police officer's report somewhere to say that this victim brochure was provided to the victim. It was provided in writing. It was mailed to them. It was provided on scene. Whenever it is determined that that person is a true victim of a crime when they receive that brochure. Because if we look at it and there is no documentation to show that this brochure was provided to the victim, we're going to go ahead and maybe assume that that victim may not have gotten that because there's no documentation on it, so therefore were not aware of what rights were available to them. Okay, there's a few things that the VRA does not cover. Again, cases filed by municipal court, police misconduct. Now, if we get cases like that, I'm typically going to refer the victim to file a complaint with Internal Affairs. Unless the case is made that the victim was not treated with fairness and respect and dignity, then we may look into that one a little bit closer and determine if there's a violation of the victim rights there. The manner in which a case is investigated, and the decision as to whether to file or not file charges. The plea agreement. The victim has the right to be notified and consulted that there is a plea agreement, what it is, and consulted on it. However, that victim doesn't have to like the plea agreement or necessarily agree with what the DA is presenting. So if a victim files a complaint, there are two types of complaints that our office gets. There's the informal complaints, which is typically a phone call that a victim would make to our office. And what we're going to try and do is resolve this at the local level. So we're going to contact the agency. We're going to maybe find out what's happening with the case, if there's a status of the case, maybe what the update on the case is, if we need to reach out to the officer, and then hopefully give the victim a call back and provide them with that information, or encourage law enforcement or the victim advocate to reach out to the victim to see if they can resolve it at that local level. Sometimes that doesn't always happen. So if we can't resolve it at the local level, what we're going to do is we're going to have the victim file a formal complaint, and if they submit for a complaint, all formal complaints need to be reviewed by our VRA subcommittee. Our VRA subcommittee has 7 members on it. We have a judge, a chief district attorney, a district attorney victim witness coordinator, a chief or police, a chief of police or sheriff, a victim of a major crime, a rural representative from a DV sex assault program, and a community representative. I think this group is very well rounded. They have a lot of wealth, a lot of information that they're going to be providing to the sub to review our cases, which is great to have all that knowledge, and I think it's an unbiased decision. The goals of filing a VRA complaint is to reach a resolution, prevent future violations, and system improvement. We want to make sure that what happened to this victim doesn't happen again to another victim in the future. It's all about system change and what can we do to make it better so this agency doesn't violate again. What this is not, it's not a do-over process. So a victim doesn't have the right to have their case heard all over again in court. They don't have the right to have the law enforcement agency do a whole nother investigation. So it's not a do-over process. Again, our number one complaint is not treated with fairness, respect, and dignity. And what we do when we get these complaints, we're going to look for a pattern of unresponsiveness. So when I use the example of that victim who kept calling and the officer didn't return their call, and really all the victim wanted was an update on the status of the case, we're going to look to see if that officer tried to call him back, or if there was a pattern of unresponsiveness, that the victim may have left 3 or 4 messages with the officer, maybe left a couple messages with the victim advocate, and nobody returned their phone call. That is a pattern of unresponsiveness. Even if there's not an update on the case, please contact the victim back. Let them know that there's not an update on the case, but you will follow up with them as soon as there is one available. And again, was it an egregious act? Did they intentionally not call the victim back? Did they intentionally be rude to them or yell at the victim? So if there's a complaint and the Victim Rights Act subcommittee has determined that there is a basis in fact violation for the allegations in the case, these are some of the requirements that we may ask for an agency to complete. So we're going to look at some Victim Rights Act training. We're going to ask for them to maybe review their policies to see if their policies include what that violation is, and maybe change their policies, update them so that we don't have this problem again. A victim empathy training. And then meeting with the victim. If the victim feels that this is something that they would like, we're going to ask the victim if that's something that they would want to meet with the police officer or the victim advocate or a sergeant in the case maybe. But we are going to make sure that that's something that the victim would want. We never force a meeting for compliance if the victim was not okay with that. When we look over the past 10 years of the formal complaints that our office has received, you'll notice that the district attorney's office and law enforcement agencies have the bulk of the complaints. That's not because they're doing a worse job than the post-sentencing agencies, but what it is because they have the automatic, they have the bulk of the VRA. So they're going to have the most complaints because they have the most notification. So it's typical that they're going to have more complaints. You will notice that in 2017 we did get a few more complaints on judicial, so it looks like they possibly are maybe on the rise of getting complaints. Maybe victims are feeling more comfortable for filing these complaints. Not quite sure, but it just seems that that one is also on the rise. So things to keep into consideration when you're working with the victim. Again, can't stress it enough to document everything. Document your contacts. Document that you've provided the victim rights information. Document that you've provided victim compensation information. And all the notification on critical stages. Any status update that has happened in the case, make sure that you're documenting it. Because again, if we have a complaint, the first thing we're going to do is we're going to ask for your documentation. Where are your victim notes? Where is the police report? And if it's not listed in the police report and the victim notes that this information was provided to the victim, then the subcommittee is going to go ahead and determine that that victim may not have received those rights. So if anything else, please remember to document everything. If you guys have questions or anything else comes around, you're free to give me a call. This is my direct line. You can email me. You can call me. I always encourage people to contact me if they have questions. Maybe we can help resolve it prior to it becoming a formal complaint, and that our office wants to work with your office so we don't have any complaints moving forward. Thank you very much and have a great day.